My Lord, having regard to the nature of the allegations, my Lord, my only submission in defense would be to tender an unconditional apology, my Lord, on behalf of the hearing lawyer, my Lord. And, my Lord, I undertake that I will not utter any such utterances in future. My Lord. Other than that, my Lord, I don't think I have any other submission.
Mr. Mahato,
My Lord.
because this has to be brought to its logical conclusion.
My Lord.
So then since it's a criminal contempt, you'll have to give evidence by way of affidavit.
My Lord. Correct.
Then a reply or what you call affidavit by you, and then
No.
we take up the matter for hearing.
My Lord. My Lord, because your Lordship kindly, but there is.
Well, it's not a case by which an unconditional apology can meet it, taking into account that already there was an unconditional apology on the earlier round, and there was also, no, Mr. Chaudhary, listen, and there was also that an undertaking that such act would not be done in future. If we say that after that, again, you could tender an unconditional apology and let you off.
Lordship may put him under probation. My Lord,
We have already suspended him for a particular period. We have done it and also kept a sentence which is suspended. So therefore, I think the best way of there, we cannot close it in this manner. Now. They have to lead evidence, and you.
No, I was thinking otherwise, not without doing. You have of the day, since it's a criminal contempt, evidence has to be laid.
If it is the first round, or if it's a civil contempt, it's a different thing. But this is a criminal contempt.
Followed. And my Lord, in fact, in that affidavit regarding the previous case, not a single line there.
It's okay. You can lead evidence
My Lord.
by way of affidavit.
My Lord.
Consider that.
My Lord, that will no, question of my Lord. Since he admitted, when they admitted, my Lord, then there is no question of any evidence, my Lord. On basis of their admitted position, because they have not denied it, they have not done it. So your Lordship. Criminal contempt. Criminal contempt of certain. My Lord. Yeah, no. He can only complete it.
No, you see, Mr. Mahato,
My Lord.
there are two things. That's what we discussed right now. There are two things. Number one, even if there is an admission, but there is a right of the respondent to cross-examine.
My Lord. My Lord.
So that he loses, and therefore there remains a lacuna in the proceedings. So even if you file an affidavit saying that there is an admission in this paragraph, so therefore no evidence is required to be led, even that has to come so that the witness can be on the dock, so that he can have the exercise the right of cross-examination.
My Lord. No, my Lord, actually, I just wanted to point out that the clause, my Lord, High Court rules. Page 283. If such person pleaded guilty to the charge, his plea shall be recorded, and the High Court may, its discretion, either convict him thereon or accept his bail for in appearance such time as may be appointed to receive the
clause?
My Lord,
You're
that is, my Lord, criminal 8182. Page 283. Page 283.
This will only come when he pleads just guilty, but he is not doing it. There's a demand out there to the effect that he was not in conscious mind.
My lord, my lord.
So therefore, you have to come up and give your evidence to that effect. You cannot prove him that he has. It is he who has to prove. He is the proponent of that particular defense.
No, from their pleadings.
No, and therefore this is what we exercise by taking an affidavit, we granted him bail.
My lord,
That's what we did. So therefore, there was an affidavit first and then we granted bail.
my lord. Well, he may be appointed to receive his judgment. So, question of judgment is there, my lord. Your lordship kindly see for the appearance and such time as may be appointed to receive his judgment. Actually, judgment will be. But the order is the meaning obligation. Anyway, after the person.
We need to initially, it will
Question of ये वहाँ पर लगा हो.
we fix the matter for taking of charge.
My lord, that is,
Arguments for taking of charge,
my lord, that is,
then they are upon the proceed.
yes.
Then the question of evidence.
That is been a month of May, my lord. We have to buy them.
But Mr. T.J. Mahathir, Anil. Senior counsel. Standing counsel for standing counsel for this court, assisted by Mr. A. Barwal, and counsel for the also for Mr. Ken Chaudhary, and senior counsel, assisted by Mr. R.M. Vas, and counsel for the respondent. Next, respondent in person is present. Next panel. From the affidavit filed by the respondent on 5/3/2026. Does not appear that there is a candid admission of the respondent is guilty of the charge. As he has explained his physical and mental condition, which led to the Facebook posts. Therefore, comma. But we'll have to ask you formally that whether you plead guilty of the charge. No, you definitely not.
If it is to, when lordship is proceeding in that manner, certainly not, my lord.
Next panel. The on behalf, with instructions from the respondent and respondent, from the learned senior counsel for the respondent submits that the petitioner does not plead guilty. Change that, you say that as the respondent is present, on being asked, he does not plead guilty of the charge, he does not plead guilty. Next, accordingly, the matter is fixed for framing and hearing on charge. Next, list on when.
But the first week of May, there will be slightly, maybe after 12th of May, Miller, any date. It will be 14th May, Miller. Well,
14/5/2026.
well, deep.
Your, because of that. With some clarity in the political field also.
And by council election also.
But we don't find your name in the newspapers. You are not making news.
No, I don't intend to also. It's better to be a kingmaker than to become a king. Yes, first week, Miller. The first week is fixed. Deep, Miller.
I'd like to mention for listing one item also on for motion on
Give it
6.
to the courtmaster. Give it to the courtmaster.
Wait, please. I'd like to mention item number
Just
4.
wait, he's senior to you.
May it please your lordship. Item number 3, lordship, I just want to go through the records now.
Definitely. Good. Allow the box.
Deeply applied.
My pleasure, Your Lordship. My prayer for listing for motion, Your Lordship, habeas corpus matter, Your Lordship.
Wait, please. Maybe with regards to item number 4, 12, 13 and 14, my lord. Landed senior Mr. M.U. Mondol is on leave. We have also reflected in the cause list. Maybe adjourned for the day.
Just wait and renew the prayer when the matter is called, because we have to look at the records and then pass orders.
Obligation.
We'll consider your prayer, but let it come.
May it please the lordship, item number 21, can it be taken after Bihu vacation? Lordship, the council M.A. Islam, he suddenly,
No, it's okay, but it's 2019 matter. Please wait till the matter is called.
obliged.
It be the lordship, item number 7 can adjourn for that.
No, please wait till it is called.
Daily list item 1 for motion.
We can kindly see the annex 4. Implement order with that. Implement order is will have
41.
Page 41 to 52, 51. After receiving notice, I filed restatement and also the evidence. And mother also deposed and on the concern authority also deposed.
Which page is exhibit A?
Exhibit A, Miller, that is yes, Miller, that is there is a relief eligibility certificate, Miller, which is issued by the company
Which
authority.
page?
Page, Miller, and a relief. Page 52. type copy and next will have photostat copy, but not very clear. Kumar Namodas is the father and father legacy. Father legacy. And also, the petitioner Rashid is trying to submit application under section under K this is the competent authority. That is proceeding going on.
Which is your real statement?
Mr. Kindly see page 13 to 16 and 23 to 26. Then another the additional investment. First we have page 13 to 16.
You see, everything is okay, but unfortunately, because you have a written statement, you have failed everywhere. Your document says you were an internee in the Matia camp, camp number 10.
Well,
In your written statement, you say that you are born and brought up at Dudhnoi camp. But then there is a mismatch. That is why everything is rejected,
one.
except for that error.
And also, the petitioner is my process is going on. We have to file application under
That is
CAA
something else. That is outside the court.
outside the court.
So bank can sit together, but
And if that is filed and come again, we'll have to see. So, no, if
we don't know. You see, here the problem is that you don't have an evidence. Your the written statement destroys everything. Yeah, don't let him take a call. Because except for this written statement, everything is okay. The tribunal has accepted Exhibit A.
oh,
They said that it's come, this is the document accepted. But then written statement is Dudhnoi camp. Dudhnoi camp, she was never there. Once you say Dudhnoi camp will destroy your evidence, complete destruction of your evidence.
yes.
And the Mr. Pai, the lawyer doesn't even care to read the documents he is having. Look at the document here. You flagged it. See the seal.
Yes.
Camp number 10, Matia. He could not have written Dudhnoi camp.
Probably because my understanding, my place, I know that place. Name is Matia, Dudhnoi, but place located in Matia. Just like
You
a
see,
FP, on camp is there, Milord, now at present.
that's not so
Forest
easy
Tribal
to-
camp, Milord,
That's
this
not
camp
so
at
easy for
Golpara,
us
but
to
that is Mornoi.
That's not easy for us to accept.
Yes,
The reason is the distance between Matia and
Dudhnoi.
Dudhnoi is about 19 kilometers.
No, probably not.
It is 19 kilometers.
I am from the locality, so I know the distance not, about hardly not, within below 10 kilometers, maybe.
Then you are challenging Mr. Google.
No, I'm not listening,
Yes.
Google,
When
but
I-
my,
I cross-checked it and then only I told.
from Dudhnoi Milord, there is a one college and then only field Milord, then Matia starts.
So we don't know this camp, but the camp, the distance between the two is.
I have also, I have not got any chance to
No, we
visit.
don't know. You see, at times when we were young, 20-25 kilometers in village, people will say, there, just go there. 20 kilometers walking is in village is nothing.
Sorry, Transit came Matia.
I did my homework.
Dudhnoi. By can, under, there is the National Highway, Matia, Agia Road.
Mr. Pang, look at that. I've checked with camp, Matia camp and Gundoi camp. 18.9 kilometers. So therefore, Gauhati and Gurjar Airport, it's not that close to.
He has this document, but it can apply for.
Huh?
They want.
Just have done it. So, both sides are represented. Pursuant to orders passed earlier, the records with tribunal is received. Accordingly, the court is inclined to issue rule returnable forfeit without requiring any fresh steps to be taken. Next one. This is the matter for hearing. The week commencing 18/5/2026.
Item 2.
May I place your lordship? Lordship machine here is on leg at court number 15. Kindly pass over for time being. Obliged, lordship.
Item 3.
It's in the voter list, letter photo, 2016.
Yes.
Yes, lordship, in this case, petitioner has exhibited voters list of 1966, 1965,
65, 70,
79, 85, 89 of her parents' lordship. And 2016 voters list, 2000 is not there with us. 2016 voters list lordship, wherein her name appeared along with her paternal family. Her mother's name is there. Meanwhile, her father might have died, so her
No, but you see, the problem starts because your father interchangeably used Ganesh Mandal and then says Ganesh Biswas.
that clarification she has given lordship.
You see, it's a general, what they call generally acceptable proposition.
Yes, sir.
65, 66, and 70.
Ah,
The voters list normally doesn't change. So you will find here in 65, the voters list, their surname is different. He produces as in 66 voters list also. There the house number changes and the age changes.
yes, 66.
That is very rare. Normally 1965 and 70 is normally the same.
Her father in 66, her father's name is there as Ganesh Mandal lordship.
Yes.
70 also Ganesh Mandal lordship.
Before your link with that 65 is snapped.
Then in 79 also only Ganesh. Surname is not there. Her surname is Biswas, means her marital surname is Biswas lordship.
You see, this we are not finding anything to overcome this observation. When you come to page 15, subparagraph D of paragraph 5, last 4 lines. It is for this reason tribunal insists on production of sequential series of voters list of all family members. Here OP's mother suddenly appeared in 1985 and therefore the other voters list of her father cannot be accepted. In other words, she has failed to establish linkage with Ganesh Mandal appearing in voters list so as biological father.
Citizen privileges and protection of sequential series of official assembly appeared in 85 and
Then is the explanation by the tribunal why that evidence was discarded.
in other words, she has failed to establish a clear linkage with Ganesh Mandal appeared in 66, her own biological father. My prayer will be, Lordship, here, she has exhibited Gaumbuda certificate, which she has not duly proved. So if the matter is remanded back to the tribunal, she can prove that, and even her cross-examination was not done, and even DW2. So my humble prayer will be, if the matter is remanded back, Lordship.
That we can't remand the matter, you know the law.
So cross-examination of DW2 was also not done, Lordship.
No, that may quite be possible.
And she has exhibited a land document which was also not duly proved. Land document Jamabandi also she has exhibited.
You see, the tribunal, what it was, it asked questions under 165.
Yes, Lordship, that I think. I think so.
The family is not together. In this voters list, the family is not together.
In 65, Bishokha Sundari is there, Shanta Viswas, and in 66 also, Bishakha Sundari is there. Then Shanto and then Ganesh Mandal. But age discrepancy is there, Lordship.
No, you forget about the age discrepancy. We are not on majorly on that when other things are acceptable. If you can come to page 23. So you come to page 22 first, then will tell you the sequence. 22, she says that she has 6 brothers and 5 sisters, 4 sisters.
Yes, Lordship.
Now, she gives the name of 6 brothers. Page 23.
Yes, Lordship.
Then last line is that মই বিয়াৰ আগতে পিতৃ ঘৰত ভোটদান কৰা নাই. Before, after going to the matrimonial family, that vote was
Yes, Lordship.
given. But then the brothers and all, their presence is not recorded anywhere. To make out a family so that
Linkage document she has not proved, Lordship.
No, not even that, the court, the traveler has rejected your pata at page 33 on the ground that the continuity of this pata is not known.
Subsequent Jamabandi she has given, Lordship, but this Jamabandi, Lordship, I just, I could not complete my going through the files because the Jamabandi, the patta number which is given, I just wanted to check with the annual Kiras patta which was given, whether.
Not yet. You'll not get that. Because it's Javandi, in Javandi, what you will get is that land which is otherwise permanently settled.
If she would have proved this Jamabandi, whether it was given through settlement or not, that would have been clear, but that
Yes.
document,
The settlement.
no, subsequently whether that land was being settled and then subsequently, but this document also is not proved, Lordship. Wherein in the Jamabandi, her father's name is there.
Which is your first voters list? First voter.
Her first voters list is 85 voters list, Lordship.
Where is that?
It's at page 35, Lordship. With husband. Linkage is not
After
clear.
85, which is the next voters list?
He has exhibited 85 lordships and her own is 85. That is the one she has exhibited. And 97 is there, but I think she was marked as D voter. So in the certified copy, her husband name is there. So 85 voters list only she has exhibited. And linkage is not there. The document which she has exhibited, that also is not proved, Lordship. Hmm?
In summary, you have given the date of death of your father. What is the date of death? Year of death? Yes, yes, summary it is there. So that is so 18 years ago. Father died 18 years ago. So 2001. 2001. No, that's the 2001. 2001 he died. Name of your father was Ganesh Mandal. Hmm. I you better go through these records. Really conducted case. The people who are dealing with this file have no idea about what they are looking at. And Ms. Ghosh, it includes you. There is a copy of two pata, Mr. You forget the Javandi. There is this copy of two pata somewhere. Yes. Can you read this pata? First one. See the year. You get the year. '57. Correct. Now look at the next one. Can you get the year? 1947. Now look at the rules under which it is given. Down below in that patas. Second one. Colonization settlement rules. These rules were prevalent in 1945. Yes. And this is no longer there. It was there under the Assam Land and Revenue Regulation and thereafter discontinued. After, I don't know the year, I forgot. So, this Ganesh Mandal has his roots since 1947. Oh, but, and this document was not put. And you lose everything. You lose everything. And then there's a Jamabandi also. Nobody read this Jamabandi. That the annual pata was converted into a carry pata. Then you lose everything. It's something you can't salvage. Something you can't salvage. Yes, I don't need to think of a way. We don't. So we'll be following the curtain that's. What's represented? D. Ghosh, for the petitioner submits that he was not in touch with the petitioner for quite some time. Before he waits for some time to obtain instructions. Next, as the records is received, court is inclined to issue detailed notice of motion, return over on 6/5/2026. without requiring any steps to be taken. List in the admission column on 6/5/26.
Item 4.
You made a prayer for adjournment. Both sides are represented. As the records of the tribunal is received. So you can cause the tribunal is received. So how about the alia counsel for the petitioner prays for adjournment? Next paragraph. Issue notice of motion returnable on 6/5/2026 without requiring any step to be taken. List in the admission column 6/5/2026.
Item 5.
The petitioner has no voters list with his father or grandfather. Not with father or grandfather. So the only link was that school certificate, which was not proved. 40. Yes. Yes. But the author did not come and exhibit. Because we did not find it, we may be wrong. We don't read so thoroughly. Arnold, please repeat again. So the name appears in not only 70, 70, 85, 89, 97, 2005, 15. But how do you link to him? Yes. 70. Yes. That is how we were trained to find out tutored witness. We are also trained in similar manner. Take a break and come back. Yes, we are there. Can you give that citation? Can you give the citation? Give the citation. Thousand. Yes. Two thousand nine. 2009.
Now, yeah, that's good. But it's not like. One of that. That is. But.
This Supreme Court you have cited, have you read that judgment? You are citing it from the head notes or you have read that judgment? You read it. Can you tell us the facts of that case? Can you tell the facts? The ratio is not applicable because that was a case under 112 of the Evidence Act. But the fact of that case was that there was a question of legitimacy of the son, and therefore the Supreme Court says that in that case what had happened was that the father gave admission to that child in the school, and when paternity was disputed, he says he is not my son, and therefore in that context the Supreme Court says that the school certificate which was entered by the father describes him as a son, and therefore it can't be discarded. So it's not a case where the subject matter was that entry in the certificate. In a paternity suit, either it will be section 50 which applies or 112 of the Evidence Act which applies. So therefore, when father gives admission to the child, claiming him to be son, then he cannot reside. That's the issue here. But this is here your citizenship is disputed. Principle of law is on the facts on which it is decided. A paternity suit can't be compared with this citizenship. Yes, yes. You make a prayer when the matter is called. Yes, specifying. Please put on your speaker. I think it's.
Sorry. Admittedly, in this case, my lord, the school certificate is not proof, the linked document. And that is admitted, my lord. And secondly, my lord, if your lordship may see, my learned senior friend has placed some documents. The saying that, my lord, 2015, the petitioner's name appearing along with his father. That is another document which my lord, learned senior friend is, my lord, relying on. But if your lordship may see the
Yes.
second thing, my lord, your lordship may kindly see. The petitioner is trying to link himself with one, my lord, Mohiruddin Sheikh of 1970 of Dhuakura village. That is at page, my lord, 24, particular. The serial number 328 is the
Yes.
the serial number 328 is the Mohiruddin Sheikh matter. He is trying to link himself to this Mohiruddin Sheikh. Now, the persons whose names were there in 1970 were Malad, some Pasan Ali, Sakina Khatun, Korimon Nessa, Usman Ali Sheikh, Mohiruddin Sheikh, and Parboti Nessa. This was in Dubakura village in 1970. This is the basis, Malad. Now, if we ignore other parts, Malad, even in 1985, again one Mohiruddin is there at page 31, Malad. Who are the persons there, Malad? Not a single person other than Mohiruddin is there in 1988, 1985. Mohiruddin is there, Nessa Khatun, Moinuddin, Pulban Nessa. These were not there in 1970. Korimon Nessa was there. Now it seems in 1985 it is, my lord, in Guguduba village. The village changed it. Village changed here in 1985. Guguduba. Same thing in 1989, my lord. One Mohiruddin is there.
1970, what was the village?
Village is Dubakura, my lord. Dubakura. 1985 it is Guguduba.
Yes.
So 1985 and 1989, my lord, page 33. The names are almost similar, my lord. They are consistent in 1985 and 1989. Now, the petitioner's name first appeared in the voter list in 2015. According to him, at page, my lord, this is at page 41, where the petitioner's name is appearing as voter, my lord. Page 41. Who are the voters here, my lord?
Just a moment.
Yes.
After 33, page number?
My lord, page 41 is the 2015 voter list, my lord.
Yes.
Now, here it is totally it's a different names together in voter list of page, my lord, voter list of 2015, page 41. Except Mohiruddin, other names are not adopted. My lord, may kindly see in 1985.
This is village.
Village, this is different village, my lord. This is in Hasduba.
Hadoba.
Hasduba.
Hadoba.
Hasduba.
Yes.
Even the mother, projected mother's name in 1985 was Nessa Khatun. That Nessa Khatun become here as Posiron Nessa. Page 25, 41 mother. Serial number 479, this 480, this becomes Posiron Nessa.
Yes.
Now other names were not there. And one thing, my lord, the 2013 another voter list is there. There these names are there, except this petitioner name, petitioner's name, my lord. Petitioner, as per this voter list, my lord, was 25 years in 2015. If he was even in 2013, his name should have been there in 2013 voter list.
No, you're not following. You are referring to this page 41 and comparing it with which page?
Page 80, page, my lord, 31.
31.
85 voter list. In Guguduba, which was village, my lord, as well as, my lord, the another, the page 7, page 24, my lord, that 1970 voter list. So if we compare these three documents, one is of 1970, prior to 70, in the village of Dhubakura, one is of 1985 in the Guguduba village, and another is of, my lord, 2015 at Hasduba village, where the petitioner's name appearing in the voter list. Now, if we see, my lord, except this Mohiruddin, in 1971, in fact, it was Mohiruddin Sheikh, but in 1985, it is Mohiruddin. But their, my lord, wife's name was shown as Nessa Khatun. And now, in 2015, my lord, it is Hardupa. The wife's name is Poziron Nessa, wife of the projected father. He has given in his WS, he has said, my lord, the Nessa Khatun is the nickname of the, my lord, of Poziron Nessa. But he has not proved that, except giving simple statement in the WS, there is no proof to that. And other persons, my lord, those who were in 1970 and 1985, those names are not here in 2015. Why I'm relying this, my lord? Because my learned senior friend has annexed a, my lord, copy of the judgment of the Honorable Apex Court in another case, where it is, my lord, in para 3, it was page 49, my lord, that Kafatullah and Kamatullah, that spelling and some minor discrepancies can be ignored. Yes, it can be ignored. But the consistency in the other's name, in the voter list, if other names are consistent and family members are available from 71 to 2015, then the minor spelling mistake can be ignored. But here it is not there. Here it is not there. The family members are not appearing together from 1971 to 1980. Everywhere, my lord, the names are changing. In 1970, it was different names, set of names. In 1985, it is different set of names. And 2015, it is different set of names. So that is my point. And one thing my learned senior friend has argued, my lord, that the NRC part, that NRC document, being, even though it is downloaded copy, it may be accepted. In fact, my lord, the Honorable Court has numbers of occasions has clearly said the NRC, my lord, 1951 NRC, which was, my lord, prepared on the Census Act, cannot be accepted as a valid document, evidence, valid evidence. That is 1970, my lord, in fact, it was decided in 1970, Assam Alert 206, in my lord, the Bhavesh Sheikh versus Union of India case. Thereafter, that proposition, following that proposition, numbers of cases have been disposed of. Two only cases I would like to, my lord, refer. WPC 6090 of 2016.
This is to counter which judgment you said,
My lord, NRC,
NRC.
yes, NRC being downloaded copy, it can be accepted as a valid document. The downloaded copy of the NRC may be accepted as a valid document.
Yes.
One is, my lord, 6090 of 2016, Abdul Mojid versus Union of India. That is decided on, my lord, 15
Mojid, how do you spell?
Abdul Mojid, ABDUL Abdul, Mojid MAJID versus Union of India.
Yes.
Then, my lord, another is WPC 6443 of 2017.
WPC
6443.
Oh.
2017, my lord, 2017. Ahitan Nessa, AHITAN. Ahitan Nessa, NESSA versus Union of India. And first, my lord, it was 1970 Assam LR 206, my. 1970 Assam LR 206. The first point was 1970 Assam LR, it was said, my lord, it is under censorship, so it may not be accepted as a valid document. Second thing, my lord, the second para 11 of the, my lord, this 6090 of 2016. Same thing is here, my lord. Para 11, 12, and 13, 11 and 13, my lord. 11, it is said, my lord, considering the single-man judgment of the Honorable Court of 1970, held that
You are referring to which judgment?
my lord, the Abdul Mojid.
Abdul Mojid.
Yes. Para 11.
Yes.
It is said, as the single bench of the Honorable Court category held that NRC extracts produced to prove domicile of India in India is not admissible in evidence for any purpose. We are in complete agreement with the views expressed by the learned single judge in so. The exhibit 1 is no evidence in the eye of law. That is, my lord, the NRC downloaded copy. And further, my lord, it also said, para 13.
Yes.
The two documents, those, my lord, the NRC documents, are not admissible in the evidence for a simple reason that those computer-generated statements, in the absence of authentication or certificate by competent officer of department as per requirement of Section 65B of the Evidence Act 1872. That must, my lord, even though it is, my lord, not a, my lord, NRC document, then also if it is a, my lord, downloaded copy, then it has to be compelled, my lord, the Section 65B of the Evidence Act has to be followed. That certificate is not there. Same thing is said in the other judgment also, my lord, that the computer-generated statement of NRC, para 13 of the next judgment, my lord, Ahitan Nessa, obtained from the office of the state coordinator NRC in the name of Abdul Rahman Mandal, without entering into the other aspects of the matter. The other aspect is, my lord, that the NRC is not genuine. NRC cannot be accepted as evidence. It can be stated that such computer-generated statement without certification of a reasonable officer, responsible officer of the document department, would have no evidentiary value, having regard to the provisions contained in the Section 65B of the Evidence Act. That has to be followed, because that was this opinion is of 2019. Now probably law has little bit changed, madam, after the. Another aspect, my senior friend also mentioned about the school certificate that it need not be proved. There are numbers of judgment of Supreme Court as well as High Court of Dishonorable Court. Only one thing, madam, old judgment. This is relied on in various times. The Viratmal Singhvi case, 1988, Supply Supreme Court cases 604. Here, of course, the dispute was
Viratmal Singhi.
my lord, 1988 Supply Supreme Court cases 604. Here, details discussion has been made, my lord, from para 13 to 16, 17. In fact, in this case, it is said, my lord, it is not the record, not only the record. The headmaster who entered the, my lord, date of birth, he has to come and he has to give the evidence. Because he had the personal knowledge who entered the, my lord, that has to be proof. The headmaster has to come, no doubt. But further, it is said not only producing, my lord, mere producing the record will not prove. Who has given this, my lord, in this case? Who has given the, my lord, who has recorded this, my lord, the recorded there in the, my lord, register? He has to come. That happens. So, and under such circumstances, my lord, my submission is that, my lord, the tribunal has committed no error. And as your lordship is sitting in the certiorari jurisdiction, my lord, my humble submission is that if there is no violation of the principle of natural justice, my lord, if the evidences which were placed before the tribunal are considered by the tribunal in a proper manner, then this honorable court may not interfere under certiorari jurisdiction. That is my humble.
Mr. N.U. Mahmood, learned counsel for the petitioner, and so for the respondents. Records of the tribunal has been received. Next, as this writ petition is pending in the motion column since since it was filed on 29/7/2019. With consent of all sides, the matter has been heard. So, arguments concluded, order reserved.
Item 6.
May I please do that? I am appearing on behalf of the kindly matter may be adjourned after verification without treat. Material counsel is out of station.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. Next, as the record is received, court is inclined to issue notice of motion, which is made returnable on 29/4/2026. List on 29/4/2026.
Item 7.
Due to some medical emergency and from Camera unactive. Scientific after.
Item 8.
The travel is received. It requires examination, issue notice of motion returnable on same 4th May 2026. List in the admission column on 4/5/2026.
Item 9.
Yes. Please put on your speaker. Is a speaker on?
Yeah, my lord. The impin opinion here is at page 54, my lord.
Yes.
It is dated 29/11/2018, my lord. Here, my lord. Here, my lord, the petitioner, for his link with his grandfather as well as father, my lord, he has exhibited total list, my lord, and adduced evidence of his younger brother as well as mother, my lord. They were duly proved by the learned tribunal, my lord. My lord, petitioner's grandfather's name, my lord, Sadaruddin Malaz, was recorded in the electoral roll of 1966, my lord. Page 14, my lord.
But how do you link?
My lord, in fact, my lord, on,
Do you have any voters list with your father?
father, photo list, my lord, father's name
Father,
is Vishal,
both are available in the voters list together?
page 20, my lord.
20.
Yes, my lord. Vishamia is the father, Tyron Nessa mother, Abdul Kadir, Miss Hasna Khatun, the wife.
Yes.
Lordship, my lord, and come to, my lord, the written statement, that's page 32, my lord. Page 32 is a written statement, my lord, wherein my lord, he has disclosed about his family, my lord, starting from his grandfather, my lord, and his spouses also, my lord. This means, my lord, siblings also, my lord.
Sir, but please see this, come to page 33,
My lord,
paragraph 8.
my lord. There's a,
Yes, Mr. Hawk, how do you reconcile it with your submission in this case?
the father named Vishamia, mother named Tyron Nessa, and wife named Hasna Banu appeared in the voter list of 1989.
You don't say your name. In your evidence, you don't give your name. You, in the next paragraph 9, you say the name Abdul Qadir appeared in voter list of 1997.
And this voter list, my lord, of 89, my lord, that was executed, my lord. And wherein, my lord, is,
But in your evidence, you say your name. So this Abdul Qadir must be somebody else.
and it is, in the evidence, my lord, here is stated, my lord.
I don't know, we are showing you page 33, 34.
I mean, it is a written statement, my lord. And the evidence is page 36, my lord.
The evidence will is out. Okay, we'll have to rise. This also, you should notice a motion of that fifth. Came up. So that it will be good. Unfortunately, travel will see, and there is a motion. This topic. Or other matters will be Yes, Lord, I have received some instructions, Lord. My senior is coming out. In the meantime, just I placed the instruction. No, it will, अभी जो मुझे पहले आप एक चीज करते हैं।
Hello?
Sorry, ma'am. Both are. Yes, that's that's mine.
Nine.
So,
Take it the same page, no?
I understand, my lord. I also expected, my lord. No point saying anything right now because everything is, the elections have been declared. But, Mr. Mazumdar,
My lord.
uh, in your note, if you can come to E.
Yeah.
I'm also interested there. You see, what is happening
Yeah.
is that law in the foreigners tribunal cases is basically well defined between the year 2016 to 18. All sort of computational combinations which were the defense taken, those were all addressed. It is between the time of 2016 to 2018. Now, you will be correct that we insisted on the books and other pedagogues being given
Right.
to the tribunals and submitted on the project in this evaluation. You see what is happening even yesterday, we had to set aside ex parte opinion after 14 years. The reason is that the notice was not served in accordance with law. Your attorney counsel defended the state that how does the proceeding now come to know about that 14 years of order? Definitely somebody would have now searching for him and he will come to know. So that's not the ground, but this procedural lapses are there. That is one. Second is, again, the experience in the other bench. You see, the lawyering standard is coming down horribly. In one particular case, which was there today, went against the petitioner. The lawyer put on the record two pata. One is of 1947 and issued under a law which is called colonialization settlement rules. That has been withdrawn after the independence and everything. And it is 1947. So at that time, India was not independent. He got that. The grandfather has it. Father, for some reason, was in Bangladesh. Comes here, gets himself registered. The document of registration of 64. Of 64. And none of these documents are put. So if the tribunal has those records, you see, we are not only dealing with making people foreigners. We should also see that the people who are Indians should not be made foreigners. That sympathy or empathy is lacking. It gives, at times it gives a mixed feeling of whether the manner in which people are detected to be foreigners, is it fair? It is in that context we need this evaluation.
Yeah.
We also need the evaluation to not on the merit of their disposal, but to find out their suitability, whether these people are need to be continued. You see, if there are, if the evidence is not there, please do declare it. But when it's a conflict between the heart and the head, head and the heart,
Huge gap,
huh?
huge gap.
There lies the difficulty. The what so far as we take is to follow the law.
In this paragraph E, they have mentioned here that Contempt to
This-
come up with
this
a,
is something we want to do it because
something has to be done.
people are not curing themselves.
In fact, this pursuant to directions of the Honorable Court, my lord, training program was also organized.
No, but that's
Previously.
insufficient. We are finding it insufficient.
Not working.
No, you see, the problem is elsewhere. The standards are coming down. The same mistakes are being repeated. That's why I started saying that law which has been laid down in 2016 to 18, same mistakes still is continuing.
Look, one connected issue that perhaps lordships also considered previously also. I repeatedly, my lord, on the previous occasion also, my lord, requested this honorable court as well as the respondents that the minimum number of books which are required for the tribunal, along with the regular update of the judgments of this honorable court, are to be supplied to the tribunal. They made an endeavor, and till 2025, they may not supply.
There are only some missing volumes.
No, not missing volumes. In 2026, they haven't continued with that. Now, here in Lord, April, that has completely been stopped, Lord. So that will tomorrow that will create a problem, my lord.
Yeah, true.
Because your lordship is laying down law on the subject. For last the 2026 onwards will be judgments of September, October, November, December. So these members will be totally unaware about the decisions of this honorable court. That also,
My
you know,
lord, if
doubtful.
I don't have the desire to, my lord, if I don't have the desire to read, books will not help.
No, no, that's a different thing altogether.
Otherwise, my lord,
This another logic. That assessment has to be there. That assessment has to be there. But at the same time,
yes, my lord, last affidavit, my lord, says that
they have
some-
said that
some
we'll
students are
provide.
missing.
We'll provide, but fine, they'll provide, my lord, I am not disputing that, but it has to be done instead of assurances. And because we cannot say that we will not establish school because students are not
And,
there. That cannot.
ALT doesn't contain only the judgments passed by in the FT or foreigners.
No,
matter.
I'm not saying
It
GLT
contains all
or
judgment. There will be one or two judgments relating to this foreigners matters.
in GLT.
GLT, yes.
No.
maybe one.
PLT will regularly or GLR regularly
That is
reports
not the suggestion.
judgment. Correct me. There is no point.
Ah.
So my learned brother is having some serious issue. If that is the case, that may be discontinued, no problem, my lord. If books are not required, my lord, I am no one to say. But
Lordship is dealing with the problem which is different from this. Not the question of regular supply of books, etc. Question is, my lord, other
I
than
said
book,
it's connected.
in the act also certain things are there that is also not followed. What is to be done? Whether the GLT will help this? Yes.
True.
No. Books I'm not saying that for that books should not be supplied. What I'm saying is the problem which your lordship is facing or expressing now is a different
Correct.
one. Ah,
Correct.
yes. My suggestion before lordship will be in what has been spelled out in paragraph E in this letter. Lordship will direct them to be more serious and come up with a concrete format of a evaluation sheet. PP Majumdar. Yes, sir. Immediately after that.
Because of the election, or he is not in the department. He is not in the department because of the election. Should
Yes, you know.
I'll discuss. Yeah. Yes.
Yes, madam. I understand. Yes, madam.
Minor crime. All right. There is no dispute that books should be supplied. Yes. Some strong words so
This
that
is
they also
required,
take
my
it
lord.
very serious.
E is required, my lord.
E is required.
E is required.
No. Minor. Very important. That has to be broken. Yes. That is the proper word.
10/3/2026, comma, the learned senior government advocate has produced his written instructions dated 1/4/2026, received by the learned senior government advocate, comma, amongst others, comma, indicating that the administrative approval to go ahead with the work relating to repair and renovation of foreigners tribunals number 1 to 6, TO2, 1 to 6 at Silchar and foreigners tribunal 2nd Dibrugarh. However, as financial year 25-26 has already concluded, and the vote on account budget 2026-2027 has taken effect for the first 4 months of the financial year 2025-26. The available provision is insufficient for placing the proposal before the Departmental Finance Committee for administrative approval. Stop. This, Mr. Nath, when you say this paragraph C,
My lord.
you see, what we are thinking is that
My lord.
your administrative approval can still go subject to allocation of budget.
Yeah.
So therefore, you're not committing to us, but at least one stage is over. Approval is, you send the approval. It is for the finance that the work will stop then. At least one stage is over. Can we provide for that? PWD can give the approval and send it to the finance. For lack of finance, if it is there, it is, we are ahead of one step.
My lord.
Because otherwise, again, after 2 months, 3 months, they will move it.
Yes.
Then again, there will be delay. We say explore the possibility. So in this regard, the court is of the considered opinion that the public works within bracket building, bracket close department shall explore the possibility of giving administrative approval, comma, which may make subject to sanction of funds in the annual budget by the state. If such a process is adopted, comma, at least the issue regarding repair and renovation of the foreigners tribunal.
And this approval has to be from the judicial department or the NCM department. PW will only execute the work.
And they have given the estimate. Estimate they have.
No, it says, you see, their department is now saying
Right.
SP is insufficient for placing the proposal before the departmental budget committee, that is PWD. Departmental Finance Committee. Public Works Department is giving this letter.
Departmental Finance Committee for the.
That means you will give the financial, yes. So it is still in the department.
Which has been processed in the department for according administrative approval to go ahead with the work.
So A to lagi
But the first sentence, the can you see the starting of the paraphrase?
PWD has submitted the estimate to the Home and Political in the Department for Recording.
being processed.
Yes. Well, the PWD has already submitted the estimate to the Home and Political Department. And no, Home is it. This is a letter by Home. The first sentence in the C of the department, Home Department.
Approval will have to be from the Home Department. No? Home Department.
Final PWD need the approval of the Home.
Home and Political Department is required to give its administrative approval to go ahead with the work. Full stop. It is further stated therein that as the available provision is insufficient for placing the proposal before the Departmental Finance Committee for administrative approval, the Home and Political B Department proposes to process the matter in financial year to 2026-27. Full stop. Accordingly, it appears that even the the proposal is not being processed for insufficient provisions. Comma, it would be the Home and Political Department shall explore the possibility of granting an administrative approval in the meantime, which can always be made subject to availability of funds. So, if such a process is adopted, comma, at least the issue regarding repair and renovation of foreigners' travel will be one stage ahead. Next paragraph. Insofar as the issue regarding performance evaluation of the London members of the foreigners travel in the state of Assam, comma, the court hopes and trusts that the authorities shall take the matter in its, take up the matter expeditiously. Next paragraph. it may be mentioned that the learned standing counsel for this court has referred to the non-continuation of the supply of books and periodic and law journals. Full stop. We express our hope that this issue of providing law books and law journals to all the foreigners tribunals shall also be taken up by the Home and Political Department in its right time assessment. So that there is no discontinuation of supply of law journals to the, there's no delay in the supply of law journals to the foreigners tribunals. Next paragraph. As prayed for by the learned additional advocate general, this is the matter on, Mr. Sir, Mr. Muzumdar, you say that on the, your prayer, the matter being adjourned, you want to be listed when?
Second week of May, madam.
Government form hobo, May.
Second week.
Dipankar.
No, this contains is,
He is not very sure. Well, yes, I have something like this Google map, calendar, my lord. This calendar, all my chamber mates, they will have the same calendar. Once I put a date here, all of them will come to me at a time. Friday, 29, 29, 29, in the meantime, 29, yes.
29, May.
May.
Look, I'll remain out of station on 29. I'll remain out of station on 29. Yes,
Okay.
delegate again. 1st of June, no, 2nd of June. 2nd of June, yes,
All right.
Tuesday.
Yes.
Yes. Hours, yes. At 2 o'clock. There are 3.
Madam, we'll have to bring one. I'll come out with the reply to both of these guys.
Basic infrastructure requirements of an appropriate courtroom with HLAS, washroom facilities for members and staff and other essential furnitures like chairs and table is not made available. The state should file an affidavit to inform the court as to how they desire the tribunals to function without essential requirements. And to also inform.
Possibly there is some restriction in paragraph B of today's instruction. With regard to improvement of infrastructure and providing basic facilities in the foreign tribunals as well as making the basic.
See, the matter is, they haven't consumed the urgency, it has been taken up with the Public Works Department. The Public Works Department again says that we are given the. So this estimate is in respect to an estimate.
That
That estimate is only for 6.
Only for 6 and the Dibrugarh 2.
And Dibrugarh 2.
Dibrugarh 2.
So that means this is still not addressed.
It is under process for us. It is
So
going
that's
on.
okay. We are just recording it.
They have collected the data. Data they have collected.
We are recording it.
Yes.
We have data has been collected in basic.
Where the concept of those tribunals where infrastructure required is not met, should not be given a long-term paid holiday till appropriate infrastructure is created. Full stop. In this regard, the Learned Additional Advocate General has submitted that in paragraph B of the communication dated 1/4/2026, it has been stated that the details of existing infrastructure and or lacking of it has already been collected and steps are being taken for providing the basic infrastructure to all the foreigners tribunals. He has submitted that the matter has also been taken up with the highest level, considering the urgency of it, and matter is being taken up with Public Works within bracket building, bracket works department, finance department, and with the concerned district magistrates. Full stop. The court expects that on the next date of listing, a detailed affidavit be filed regarding the data that has been collected regarding available infrastructure and the lacking of such infrastructure, and to indicate the steps taken for creating an appropriate courtroom for the foreigners tribunals. Then that download to copy. But Mr. Das, one work still remains.
Sorry, Milord.
Regarding compiling of the various orders we have passed from time to time, so that case-wise it can be taken up. We only restricted ourselves to 5 or 6. So,
Look, once I tried, I gave a Milord list which contained the orders and the order passed, date of the order and the contents of the order in a bullet form, Milord. I compiled one.
that, can you tell us when?
It was when your lordship started taking up the matter after 2-3 days, August perhaps. After that, Milord, I can sort it out also.
So because otherwise we'll miss out many things.
Yes.
I understand, Milord. I'll do one thing, Milord. After August, I'll include the rest of.
Let him file a fresh one in concise manner so that.
Yes, yes. I have the soft copy, Milord. I can add the subsequent proceedings.
Do you require the order sheets?
Look, I'll just, lordship will kindly inform the court master. I'll just.
No, because this will go to section. If I.
Oh,
pass
yes,
that
yes.
pass order, then.
Yes, order sheets, Milord, it will be helpful, Milord. Milord, or it can be sent to the Registrar Judicial. From him, I can take up.
Okay. With the transfer. It may be mentioned that since the functioning of the tribunal is being monitored since the year 2015, various orders have been passed from time to time, which may require a revisit to ascertain as to whether all the orders have been complied with from time to time. So accordingly, the registry is requested to provide one set of order sheet, entire order sheet to Mr. H.K. Das and Mr. Sanikosi for the, for this court. So as to enable him to peruse the same and to inform the court as to whether there is any other requirement to follow up the orders passed from time to time by this court.
Division bench item 1, 2, and 3 for orders.
Lordship, in item 1 and 2, my learned friend Mr. Nath has just been on the court. Lordship, may kindly take up item 3 in the meantime. Deep regret.
Item C.
Your Lordship, I apologize for not having been able to file the affidavit, but I have brought all the instructions in terms of the last order, Your Lordship. The situation is not very pleasant insofar as observation on. Oh, no, this is only with regard to Assam, Your Lordships.
Right.
Huh? In rape type of children, sir. I have no difficulties filing it by way of an affidavit, but I apologize, I could not do today. They gave us the instructions only yesterday, Your Lordship.
No,
So.
So there are juvenile in the adult.
In some districts, there are, in some districts, as Your Lordship may find that the situation is quite dismal. Actually, there is a provision in the Juvenile Justice Act which says that 2 or 3 districts together can use one observation home or one shelter home. So accordingly, I think that is what is the state of Assam is perhaps doing. Some districts, like for example, Kamrup Metro has a lot of units, Your Lordship. They have 19 units. If Your Lordship will turn to page C, Kachar has 5 shelter homes and 1 observation home, page C of this compilation. Then Tinsukia also has 2. Then Baksa has 1. Then thereafter Kamrup Metro has 19 units, different kinds, and 2 observation homes, Your Lordship. So it a lot depends. Chirang is also another district which has 2 shelter homes, and page B, Your Lordship, of this particular compilation. But as Your Lordship may find, serial number 1 to 7 of page A, there's nothing, no observation home, no shelter home, no temporary home. So it's a little dismal in these particular districts.
We, just now.
Yes, sir. Last one, organic. 6 down.
Mr. Chaudhary, what we propose is
Yes, sir.
that if this copy is provided to the Mr. Nath.
Yes, sir. I already have. I've already given.
In the meantime, he will have this examined.
Yes.
To be this will be to the Women and Child Development
Okay.
Department.
Lordship.
Is it?
Finance may perhaps be required to be involved if Your Lordship proposes to have. That is the second stage, provided first let's, whether your lordships would want to have observation homes and shelter homes in each district. That is something your lordships may have to perhaps take a,
That's the
Hold
mandate
on.
of the law.
yes.
Has
Uh,
to be. Otherwise,
Like I said, lordship, there is a
Otherwise,
provision for
state
having
must say-
observation homes in 3 or 4 districts in a combined manner. So perhaps that is what they are perhaps
but for
doing.
that,
I can have space option in every district
Should have at least one, definitely, yes,
or maybe contiguous in
Yes.
Porta, Bojali,
correct. 3 or 4 districts
one, like that can be the case that they will have to respond.
respond, yes,
that is from then to come.
definitely. So
That
I've,
means
I've already
the-
provided a copy of this to my learned
We
friend.
will not say that we have combined fees. We will always do
One in each district, definitely, your lordship. Correct.
Second is that the, insofar as the juveniles in the adult jail,
Lordship.
that has to be urgently taken up.
That is very few, your lordship. There's one in Jorhat, if your lordship will take up this report itself, page 8.
Jorhat, then what is
Jorhat, there were 3 juveniles. And cases have been filed by the legal aid councils to, by the LADCs to ensure that they are moved out of the jails. That is the report that we have got. Then there is one under trial prisoner in Sonitpur at serial number 10, if your lordship will find. Yes. Shifted to observation home. Thereafter, your lordship will come to page C at Kachar district. 4 numbers of doubtful cases, and the DLSA has been instructed to take appropriate steps. Then this is 2025, your lordship. Then they have now no juveniles upon survey in 2026. This is Darang district. Now they have all been restored, yes. So most of the districts do not have any juveniles in the adult jail yet, except Jorhat. The cases have already been filed by the LADC concerned, and perhaps the magistrates will be taking up
This
the,
is one part, but the home department have to look into it.
have to look at, definitely, yes. The CGPUs, the juvenile police units should ensure that no juvenile should actually be taken to an adult jail at all. Correct.
The incident should not happen. Subsequent, by the requirement of subsequent rescue and rescue.
Yes, your lord.
Fine. Whether it is, speaking on that, that can be ensured by the home department.
You have to sensitize the police so that the juveniles are not sent to the adult jail. in the
Adult
first
jail
place.
at all, correct. Yes, your lord.
These 3 juvenile cases filed by legal aid, it has come to its fine,
Yes, your lord.
but they are inside, custody.
I think so, your lord. I'm
And
not,
that jail custody,
Yeah.
to be clear,
Hmm.
is not by police directly,
yes,
isn't it?
Hmm.
It is authorized under law.
Yes.
They are not sending it straight away, arresting and putting in jail. So some of our officers have authorized them to put in jail, isn't it?
definitely.
Can you have the details of this case so that we can take up it?
Jorhat, your lordship, Jorhat का अलग से भेजा था ना? Yes, I did.
So that we can take up in the administrative
Your
side.
lordship, can you turn to page 11 for a moment of this compilation? This is the only thing which they have mentioned, the last line, your lordship. During the jail visit, 3 numbers of juvenile being kept in an adult jail were found. Petitions claiming for their juvenility have been filed before the concerning courts by the LADC.
But there is a mandatory requirement and a duty cast upon the
Magistrate
magistrate,
to
even into looking at the
Correct.
face
Yes, Your Lordship.
without any application. They should have their own satisfaction. It's a mandate of the act,
Yes, Your Lordship.
how to exercise its power.
If Your Lordship would want me to get details of this, I can get them. No,
If we try it. if
definitely, Your Lordship. The DLSA will certainly
Might
be
have
able.
a committee meeting even before, the
Correct.
vacation.
Correct.
Okay, okay. Who are these? Why can't you? Huh?
Huh.
Sorry,
Lordship.
we request you to get the data in
Lordship.
time.
Lordship may take up next week or, आज की month, today is Thursday, कल तो बंद है. Next week है available.
Because it will help us to expedite the matter so that we propose also.
Lordship, may perhaps take it up on 7th. I will try and get the instructions before.
No, no,
No, we are not
we will have it in
doing
the
that.
administrative side,
We'll take it up. in
because you have the
assessment side.
information.
Okay, Lordship,
You can get it in the meantime, it will assist us.
of course. Your Lordship will take it up in the administration.
Mr. Nath, there are few adults in the district jail.
Lots.
You were not there, that's why we are repeating.
I'm sorry, Malak.
Perhaps this, no, it's okay. Perhaps those juveniles were sent by orders of the court. Therefore, we'll have to take it up even in the committee, that Juvenile Justice Committee, to see that sensitization programs are held. And we want to find out why they are there. Because of that juvenile thing. That's one part. The second is, this, we are dispensing with the affidavits for the time being. His report is there. Now you will have to take a call to your officers that whether you want the juvenile, the temporary home, shelter home, or whatever you call
Observation home, Your Lordship.
in every district, or you want to club to the one center to be clubbed for 2 or 3 districts. Not more than 2, I think. That you have to take a call and tell us.
Malak.
You make your proposal based on this report, how to tackle this situation.
And
If you give your proposal, then we consider acceptability.
Lordship,
And in terms of the act and the rules,
definitely.
the mandate, how we comply with the mandate? It is not our direction as such. It's a mandate of law.
Mandatory.
How will you comply with that?
PL2.
Observation
Item
home.
observation.
If they are in need of care and of this thing. Are it to shelter home, actually special home, and as per the act, there should be special home. 47 and 48. Okay. Section 47.
This is R.S. Chaudhary, Learned Counsel for the Assam State Legal Services Authority, who has produced a chart depicting data in different districts of the state of Assam regarding observation homes, public shelter homes. So the set chart, amongst others, indicate that few of the districts do not have shelter home, temporary home, or observation home, shelter home, and temporary home. And few of the districts have facility of 1 out of 3 homes. Therefore, let a copy of this chart be provided to Mr. Dinar, the senior government advocate, who would send it to the competent authorities who are required to take appropriate steps under the Juvenile Justice Care and Protection Act. Just to comply with the mandate of law regarding the keeping of juvenile in observation home, shelter home, and temporary home, comma, as the case may be. Next paragraph. In light of the said chart, comma, the state shall submit its proposal for compliance of the provisions of Juvenile Justice Care and Protection Act. Next paragraph. From the said chart, it also appears that 3 juvenile are in the adult jail in the district of Jorhat. 4 numbers of doubtful cases are there in the adult jail of Achar. Similarly, 2 juvenile are in adult jail in the district of Tilsukia. It is further seen that 9 juveniles were in the adult jail in the district of Daran, and due to the intervention of the District Legal Services Authority from Daran, those 9 juveniles have been rescued from the adult jail, and they are now kept where? Mrs. Chaudhary,
Your ships.
this page C, where are they now kept?
They have been perhaps shifted to some this thing, Your Worship, to some child, either of these 2 child care institutions, either to Kasturi Child. Let me just check. Just 1 minute.
There is it. Next paragraph.
Maybe.
Yes, by what time you will submit that?
But, in respect of just, I haven't submission, Malad. In respect of Jorhat, the social audit report I have got, Malad, there I have seen that in Jorhat, observation home is there. So the juvenile in Jorhat district, that can be taken care of.
So that's fine, you respond to it.
We'll respond. We'll respond.
No, you see, what my brother is saying is absolutely right, because you see, here again, orders of the courts are required. Because the juveniles are there in the jail because of the orders of the court. Therefore, the defense counsel, they are taking up the matter to get it restored. If the help you can do is that if the juvenility can be ascertained by way of medical and all, that assistance you can give through the district health services, so that they can have the assessment of the juvenile and then inform the court so that they are released as early as possible and shifted to an appropriate home. So your assessment at this stage is required only for the purpose of assessment.
Lordship direct within any time, Malad, because ultimately from the it will come out within 10 minutes.
Man, just here establish could lage whether they are exactly. Friday, Saturday, Sunday into Bombay also cover. Friday, Saturday, Sunday Bombay. It's a working day, otherwise working into other conditions.
Monday, Tuesday, Wednesday. Even Friday and Thursday, last day.
Just no tarik. No, just Monday. 8 tarik time and 9 tarik. 8 tarik probably. No, they are saying that they will take them after later.
Let them do it, let them by 10th, let them do it. Whatever assistance is required from outside will be. But you know that something like the juvenile is going to be have to consider, no?
Do the job and say that it definitely is some of one of our officers is find the order and send him to a bill. One matter that only one magistrate. No, they're coming to take it up on the admission. Sir, officers get down, district judge or no, it's a good part. No, no.
Okay, for the timing, you just do that.
Lordship, that lordship may direct the whatever assistance is required to determine that within a week, Malad, they will, do whatever is
Not
required.
right now necessary, I think, because see, question of your health to health will come when the justification is declared.
Required.
But if these people are having birth certificate
Or
or school
documents,
certificate,
documents
that
to
will
prove,
not
then-
come. So we are not aware as on date.
Correct.
What is the position?
We'll request the DLSA to get the information as to whether they have the documents to show that they are.
Lordship.
Yes, sir.
juvenile.
And subsequently, whenever it is required, will. Lordship.
Correct. In the meantime, the District Legal Services Authority, Gauhati, can also provide to
Yes, dealership,
the
details of the three juveniles.
to the learned standing counsel for the KSLSA, the basis on which the defense counsel have taken up the matter relating to 3 juveniles in the Gauhati penal jail. Along with the particulars of juveniles and the
Only one
cases.
Jorhat, or should I also get the other districts where there was some problem, like Kachar? They had identified 4 and they have been instructed to take page C.
Yes.
I'll probably also get, because since you also are taking up, might as well take up that as well.
3 juveniles in juvenile home, 4 doubtful cases in district Kachar,
And
and
Tinsukia, I think.
2 cases of Tinsukia.
Tinsukia, Kachar and Jorhat. Darang,
They have 50.
Darang they've shifted. So 3
Particulars
districts.
particulars of the juvenile, the office for which they have been held, and what other relevant particulars. How much time? I think which will happen is after 9th of May.
Ninth of April.
9th of May, result of
After result.
I think we should pick this matter in the month of June.
As per Lordship.
Stability will come till then.
Yep, that's
2nd June then. This chart is made a part of it.
Yes.
This person.
The approved line.
We have this case disposal ratio of the Juvenile Justice Board.
Lordship.
The reply which you gave earlier.
Case disposal ratio to level.
What about the rules?
Malad, I have received some instructions I have received.
Tell us. Tell us.
Malad, it
We
is,
are in love,
Lordship,
instead of reading.
Malab, the rules, Malab, it is, with the Home and Finance Department for obtaining views and for placing before the cabinet for approval. And same is the, Malab, the policy. And the audit report, Malab, today we have received. Social audit report has come, Malab.
Has come.
It has come, Malab. Two sets they have given. Today. But I need some time to have the copies and submit it to my friend
We
also.
just wanting to look at the plans of it.
Yes. Not-
We are not delving on it, but we are just trying to have a feel
Yes,
of it.
yes, sir.
Any summary?
Malab, the summary kindly, Malab, Roman 8, from starting page, Malab, Roman 8, kindly come to that page. List of childcare institutions given, these are the 93 page Roman 8 at bottom, Malab, middle bottom, in volume 1, at bottom, Malab, the list of these childcare institutions, Malab. 93 institutions, it provides, Malab, NGO run, government run, self-run, all are there,
Total 93.
total 93.
And these are what university?
This is done by Gauhati University.
Very good.
And what is your final comment?
But I could not, I did not get the time. But this has been given to me at around 2:30 similar.
But
I'll
must be
see.
appreciated. They,
It's a-
university have done it. It's
Yeah.
wonderful that
Yeah.
they could do it. So it paves way for the future also.
Yes, Lord, they have done a commendable job.
Hmm.
A commendable job they have done. Lot of photographs and all these
Effort is
things.
there. It's not, the effort is there.
Yes,
We will go in detail, but for a first glance on the next day, you have their summary. What is their observation after visit? Where are the problem areas? What are the achievements? And what are the recommendations? Then we'll go back individually. In the meantime, give copies to them also.
Yes.
Mr. Das will read during the Bihu vacation.
Yes, sir.
Manoj, if I may make a small submission.
Yes, yes.
With regard to the pendency of the cases in juvenile justice court, a similar situation arose came before the Honorable Delhi High Court. In that, the High Court took a suo motu proceeding as per criminal reference. It suggested that there should be classification of offences as petty and heinous. Petty offences are very well defined in there. It furthermore relied upon section 14 of the Juvenile Justice Act, which states that petty offences, 14(2) rather, the petty offences are to be first, the inquiry is to be completed within a period of 4 months. If at all it cannot be completed within a period of 4 months, a further extension of 2 months can be granted, that too with a direction and recorded reasons. Thereafter, subsection 4 provides, my lord, that if even thereafter the inquiries are not complete, then these proceedings can be straightaway terminated. If that classification is brought in, my lord, then a lot of cases may be in that stage where
Give a note on the judgment.
my lord, I have copies of the judgment.
You give a note on the.
That's it.
As regard the seating of the JDBs, notification has been issued, an order has been issued. Disposal of
This petty offense you say is under 14(2). Heinous offense is under which provision?
Heinous petty offences are defined, my lord, in subsection 45 of section 2.
245.
Yes, that is there in page.
And heinous?
Heinous, my lord, would be more than that, only petty is defined there.
Whatever is not petty will be heinous.
Will be in it. And section 14 of the JJ provides for the mechanism as to what to do.
42.
54, my lord, my friend.
Okay, we'll examine it in the next date, we'll.
Serious offences are otherwise defined in section 54.
54.
54.
54. We'll go through it and then.
Serious offences, then age limit 70, beyond that.
Even for the calculation of the age limit, my lord, there is a two-pronged approach in section 94 of the.
Magistrate without even looking at the face or.
Yes,
ask, if you feel that it's a juvenile, don't send it.
that can be
Isn't
done.
it? So it's not necessary that an application is to be filed.
No, my lord.
Yeah.
Only in a scenario where that cannot be done is the second part to be adopted.
But what happens to this disposal ratio? Have you worked out a policy, how to have the sitting?
Order has been,
Rationalization of
yes,
sitting.
my lord, order has been issued. Page number 5 of the bunch I have given, sir.
Page 5.
Page 5. Relevant is next page 6, my lord. As per the honorable court's notification, they have done it, my lord.
No, you should send a copy of this to the committee also, so that we take notice of this.
Lots of.
And you see there's another issue which we don't know how, if you come to the last page of this compilation,
My lord.
this is not been sent to this court.
No,
The
they
reason
have,
is that the juvenile justice boards, they are headed by judicial officers.
they have,
We must, as an institution, we must also know about it.
my lord, they have given to the principal magistrates of JJBs of all districts.
But
They should. Logic.
committee and the registry.
I'll
Surgeon
suggest them. my lord. Yes, my lord, definitely.
committee.
Logic.
Last order say, pursuant to order dated 5/3/2026, Mr. D. Nath, the senior government advocate, has produced a copy of written instructions dated 30/3/2026. Amongst others, stating that the legislative department has vetted the draft rules and returned the file to the Women and Child Development Department on 4/3/2026. And accordingly, a draft cabinet memo has been prepared in the e-cabinet portal and submitted to the Home and Finance Department for obtaining views for placing the same before the Honorable Cabinet for approval. To stop. It is submitted that due to announcement of elections, the model code of conduct is in force, and therefore there is no further development in the giving of in notifying the juvenile justice within bracket care and protection of children bracket those rules. So, similar statement has been made in respect of child protection policy. However, in respect of status of social audit, the learned senior government advocate has produced a copy of the social audit report, which is in 3 volumes. So it is submitted that was provided to him today, and he could not go through it, and copies of the said report could not be furnished to the others, to the to the learned counsel representing the petitioner and to the learned standing counsel for this court. So it is also submitted that, next paragraph, it is also submitted that in respect of the number of sittings, comma, revised order dated 23/3/2026 has been issued by the State Child Protection Society, Assam, which is stated to be in consonance with the notification dated 29/7/2016 of this court. The learned senior government advocate may request the State Child Protection Society, Assam, to forward a copy of this said order to the registry of this court. That the same can also be placed to the Juvenile Justice Committee. Next para. In view of the prayer made by the those. That is straightforward. This is the matter on 2/6/2026. This we are not recording it for the time being. We'll take it up on next date. We are having it, but
Just a humble request, Manoj, if till then a classification is available as to serious and. You see, I think very well at all. Very well.
Understand, he also wrote it. So instead of commenting anything wrongly, let us go to it.
Very well, man.
because we are not very clear on the definitions and those. So
What is going to go in depth?
sometimes copy and paste creates more havoc than clarity.
That happens.
Acha, record business of Mr. Yakari Chaudhary also.
And Malad, my colleagues present, Malad,
Yes.
with me, Malad. Mr. and colleague, Malad, with me. Malad.
It's there in the last order. We are
Yes.
recording, as per the last order, we are recording the names of Mr. N. Chaudhary, Mr. H. K. Das, Mr. D. Nath, Mr. N. Kalita,
Yes.
Mr. R. K. D. Chaudhary.
Not, Malad. On 2/6, Malad,
Huh?
on 2nd of June. Not.
That copy of that communication is made a part of the order. It's very difficult to just take cue from one orders and then pass orders here. Because without deliberation, if we do it.
Today, but a better order than.
Most certainly, Manoj.